Hello learners, we've been discussing about the principle of systemic interpretation for integrating environmental concerns in international investment law. So in the last video we discussed about how there's a possibility of undertaking the principle of systemic interpretation. In this video we will be looking at what are the challenges or the things that an arbitral tribunal has to consider while interpreting an IAA provision. So, the primary question that an arbitral tribunal would be confronted with is when should it apply or when should it refer to other sources of international law. So, that is the primary question that an arbitral tribunal is confronted with. Essentially, if there is an IAA and that has to be interpreted and there is an international environmental agreement, then if both the parties are same, then in that case arbitral tribunal could rely on the provisions of the subsequent treaty, which is an international environmental agreement. Or if the provisions of the subsequent treaty has achieved the status of a customary international law, then in that point of time the arbitral could rely on the international environmental agreement provisions as well. Or even otherwise the parties have implicitly accepted or tolerates the provisions of the other treaty, then in that case we can say that the tribunal could also apply the provisions in the other treaty, that is an international environmental agreement. So, that is a possibility that is there. With regard to the issue of intertemporability, we discussed the progressive development of international law. So, there IAA is there, then subsequently an international environmental agreement is signed, then the treaty that was subsequently signed, so those treaties provision will be applicable while interpreting the first treaty's provision. So, this can happen if the first treaty, our international investment agreement, is not a static instrument but an evolutionary one. So, in that case there is a possibility of interpreting this provision in the light of the subsequent treaties and the provisions of subsequent treaties. So, this is also technically a possible one. So, the fact is how do you ensure an arbitral tribunal looks at other source of the question is how do you ensure the arbitral tribunal looks at other sources of international law. So, the study group of ILC itself had suggested that instead of calling it as the principle of systemic integration, they wanted to call it as objective of systemic integration. So, that they wanted to ground this within the context of VCLT as well, because it is a given that an arbitral tribunal will have to look at the factors mentioned in article 31 and 32 of VCLT. So, they will have to look at good faith, they will have to look at ordinary meaning, context and other normative elements, and therefore, the object and purpose of the treaty. So, by calling it as objective of systemic integration, the study group wanted to ground this in the context of VCLT itself, and if even otherwise it is, even whether you call it principle of systemic integration or objective of systemic integration, the fact remains the same that this is something that is permissible considering other international law or provisions of other treaties, especially an international environmental treaty, while interpreting an IAA provision can be done through article 31.3c. So, that is a settled one, this can happen. Now, one challenge that could be asked, or one of the questions that could be asked here is, these specialized regimes like international investment law, they sort of derive their basis from lex specialis, and we all know the maxim that special rules prevail over the general rules. So, in that case, to what extent can other sources of international law been considered while interpreting an IAA provision? So, that is the challenge. So, it is true, lex specialis, there is a principle of speciality. So, special rules prevail over general rules, that is also accepted, but that does not put a bar on considering provisions from an international environmental agreement. Please note that. So, only to the extent of conflict, special rules could prevail. So, therefore, the tribunal can still look at the provisions of other international environmental agreements, and that is a possibility that can happen. So, essentially the question boils down to whether there is of course a level of autonomy in a specialized region, and when a specialized region has its own level of autonomy, to what extent can it derogate from other general principles of international law. So, that is something that we will have to look at in the past decided cases. How have the tribunal decided these cases, to what extent they have applied the special rules, that is the treaty provisions itself, international investment agreement provision itself, or have they looked at other instruments and then they have applied it. This is exactly what we saw in the lecture relating to applicable law. So, there we saw, unfortunately, not many tribunals refer to international environmental instruments. So, that is something that we already proved there. So, we can say, I can at least safely say that 31.3c is not frequently invoked even when environmental measures are challenged. So, at that particular point of time, the question is whether international investment law is a self-contained regime. It is a special regime, that is something that acknowledged by the ILC report itself, the fragmentation report itself, and even if you look at articles on state responsibility as well as ILC report, all of them have stated that the legal basis for lex specialis is still there for these specialized regimes. So, ILC itself had acknowledged international investment law as a specialized regime, and special rules can be applied. So, it can derogate from general international law, but to what extent does it derogate? And we do not see many references to international environmental agreements when an environmental measure is being reviewed as well. So, technically, is IAL a self-contained regime, or is there could be reconciliation of environmental concerns and investment disputes through article 31.3c. So, that we will discuss in the next video, but before we conclude, I just wanted to make one other point as well. If we look for a similar pattern in international trade law or WTO jurisprudence, we could see that the appellate body of WTO, World Trade Organization, had referred to article 31.3c in the context of US gasoline case, where it stated that it referred to one of the provision of dispute settlement understanding, article 3, which stated that general principles of international law would be applicable. So, therefore, the appellate body in US gasoline case had stated that the issue can be decided in accordance with the general principles of international law, and that the WTO agreement should not be read in isolation or as a self-contained regime completely divorced from general international law. This is something that we see in WTO jurisprudence. Now, the question is whether IAL is a international investment law, is it a self-contained regime, or if it is a self-contained regime, should it be treated in isolation from general international law, or there is more possibility of systemic integration as envisaged in the fragmentation report of ILC. So, that is something we will discuss in the next video. Thank you.